We are very pleased to have Dimitrios Kyritsis here with us today from Reading, and he's presenting his book, Where Protection Lies, Separation of Powers and Constitutional Review. It's a book published by Oxford University Press last year, and he will talk for about roughly 20 minutes, and then afterwards we have 3 commentators to respond. So without further ado, I give the floor to you.
Thank you so much. Thank you to the organizers. It's good to be back. I should say that this feels a bit the same, but a bit not the same, because when I started my DPhil, the Jurisprudence discussion group would meet in a basement room in Brasenose Cottage when Nick Barrow was convener. Whereas now we are in this very nicely done room. So thanks so much for booking the room, but most importantly, thanks so much for having me, and thanks also to my commentators. I hope that I'll be able to speak for about 20 minutes. I haven't timed myself, so I may overrun. Right, so the book is a book about the justifiability of constitutional review of primary legislation for its conformity with fundamental rights. And the title alludes to a phrase from James Thayer's seminal article, The Origin and Scope of the American Doctrine of Constitutional Law. So Thayer writes, "Under no system can the power of courts go far to save a people from ruin. Our chief protection lies elsewhere." The main theme of the book is that, in a sense, Thayer was right. Our protection does not lie in courts. It does not lie in any one state institution. Rather, protection of our fundamental rights rests with the ensemble of state institutions cooperating in what I dub the joint project of governing. Constitutional review is justified, if it is justified, provided it deserves to be included in that joint project. Now, how does this framing of the issue advance the investigation into the moral justifiability of constitutional review? What I think it does is it shapes the standard to which we must hold systems of constitutional review. We start by asking what makes the joint project of governing go well, and then we go on to assess whether by including constitutional review in the joint project of governing, the joint project does indeed go well. In the book I suggest that the standard we're looking for, the first virtue of institutional cooperation, is separation of powers. And now you might say, this is no progress at all. Separation of powers is a notoriously contested concept. In fact, some theorists think it is singularly unhelpful, either because it's empty or because it's only fit for states of a bygone era. I don't share their skepticism. The way I see it, the meaning of separation of powers is not fixed in the writings of Locke and Montesquieu. Rather, it needs to be worked out in light of the point that separation of powers is there to serve. And I take that point to be to enhance the legitimacy of a political regime. Now the connection between separation of powers and legitimacy sets the tone of the entire argument. We do not just want to know whether constitutional review promotes rights, protects rights, or promotes justice. We want to know whether it enhances legitimacy in the way that institutional cooperation, structured by separation of powers, is supposed to. Now, how does that help? I started with a potentially unhelpful concept, and then I referred to another contested concept, legitimacy. To show how it helps, I need to say a little bit more about what I take to be a neglected dimension of legitimacy. In the book, I call it the institutional dimension of legitimacy. In previous work, I had called it the systemic dimension of legitimacy. What is that, the institutional or systemic dimension of legitimacy? For a political order to be legitimate, it's not enough that its policies, its retail policies, are reasonably just. In addition, it must be institutionally organized so that it will reliably and systematically do the right thing. This standing assurance is an essential part of the story. It tells citizens to justify why it may rightly exercise coercive power over them, including those who disagree with state policies. In order to provide a credible assurance of this sort, it must, among other things, be equipped with an institutional apparatus that incorporates guarantees against the misuse of state power. The existence of such guarantees gives individual citizens confidence that submitting to the state's immense power does not render them vulnerable to arbitrary whim, but can in fact advance their reasonable interests in a fair way. By contrast, when the state lacks adequate institutional guarantees, it encourages citizens to defect. Without a reason to believe that their state will stay the course of justice, citizens are less disposed to submit to its rule. Enter separation of powers. Separation of powers as a virtue of institutional cooperation is one of the things that can enhance the institutional or systemic dimension of legitimacy. Separation of powers, as I understand it, is an umbrella concept that comprises a number of more specific considerations. I call these considerations considerations of institutional design because I want to distinguish them from considerations relating to what we sometimes refer to as the substance or content of legal decisions. These are considerations that have to do with the characteristics and interaction of the institutions that make legal decisions. I class considerations of institutional design under two broad headings: division of labor considerations and checks and balances considerations. Division of labor dictates that tasks must be carried out by those who are suitable to carry them out, whereas checks and balances require that exercise of public power by one institution must be meaningfully checked by another. Constitutional arrangements are answerable to these twin requirements. When a constitutional arrangement satisfies these twin requirements, it inspires confidence that government will reliably and systematically act in a proper manner. In this sense, then, these requirements help consolidate state legitimacy. They help consolidate state legitimacy because they enhance the institutional dimension of legitimacy. So this gives us a fuller picture of the structure of our inquiry. I should say that this book is as much about is as much a claim about whether constitutional review is or is not justified as it is about how we should go about investigating whether it is justified. So the structure is as follows. To establish that constitutional review is justified, we must show that it flows from or is compatible with a morally defensible scheme of separation of powers. And to do that, we must show that it thereby enhances legitimacy, understood now to include its institutional dimension. In the book, I critically consider a number of answers to our inquiry, but today I want to focus on just two, because I know that these are the answers that my commentators will want to discuss in their comments. So on the one hand, I want to discuss the answer of constitutional review skeptics, such as Waldron, And I also want to examine the answer of some constitutional review enthusiasts who take their inspiration from Dworkin. Take the enthusiasts first. The enthusiasts argue that legitimate government is one that respects the fundamental rights of its citizens. When a legislature violates one of these rights or acts in a way that violates one of these rights, it hasn't simply made a legal mistake, it has done something that it was never given the power to do. And so constitutional review is just a mechanism by which courts police the limits of legitimate state power. Now, you can accept this story about legitimacy and still doubt that it justifies constitutional review. No inexorable institutional logic dictates that just because an institution has limited power, there must be some other institution to police those limits. The reason why this is so is that fundamental rights are but one element that determines the legitimacy of a political regime. In addition, as I've said, that regime has to be organized institutionally so that on the whole, it will reliably and systematically do the right thing. And sometimes, for the sake of pursuing that goal, we must be prepared to accept discounts on perfect justice. Besides, courts can make mistakes too. If we are to give them this momentous power, it must be because by giving them this power, we are better off than we would otherwise be in terms of legitimacy. And we can't guarantee that this is always the case. In fact, this is a point that Dworkin himself made. It's a point that is sometimes neglected, it's sometimes neglected because it perhaps doesn't mesh with other things that Dworkin wanted to say about constitutional review. But for Dworkin, the test for the justifiability of constitutional review is also, and importantly, an outcome-driven one. Okay, so this is the argument against the enthusiasts. How about the skeptics? Do they fare any better? Skeptics say that an essential ingredient of political legitimacy is political equality. And political equality requires that political decisions be made following procedures that give every citizen, every citizen's view equal weight. But constitutional review, so the argument goes, gives a small group of unelected officials the power to overrule the decisions of democratically accountable legislators. It is thus at odds with political equality. Now, I have serious misgivings about the argument from political equality. It seems to me contradictory to accept representative democracy of the kind that we're familiar with and then excoriate constitutional review as an affront to political equality. The problem is that there is a very significant imbalance of power between elected legislators and the citizens that they represent. The former have the power to bind their constituents to a course of action that the latter disapprove of. They can't be revoked, they're not subject to imperative mandates, and although they may be voted out of office in the next election, this does nothing to discredit or cancel their legislative record. Now, if we don't have a problem with this arrangement, then we shouldn't have a problem with constitutional review, at least not in the name of political equality. Now, that's not to deny that it makes an immense moral difference that legislators are periodically elected and judges typically aren't. The existence of a democratically accountable legislature means that the joint project of governing includes a strong democratic input, albeit one mediated by the independent judgment of elected legislators. Electoral pressure may not eliminate that independent judgment, but it gives legislators a powerful incentive to combine in their decisions moral innovation and popular support. And that's something that a state that is interested in preserving or enhancing its institutional legitimacy should care about. In light of this, I claim that we ought to give legislators the initiative in designing public policy, and that initiative includes the primary authority to interpret the Constitution, to use another memorable phrase of Thayer's. At the same time, we have, because legislators also exercise independent judgment, we have just as much reason to check and balance their power as we do the power of any other state official. In fact, because courts are independent from electoral pressure, are independent from the legislature, and have a will of their own, that's Madison's phrase, they're good candidates for assuming a supervisory function over the legislature. But that function must remain subsidiary, lest constitutional review cancel the important contribution legislatures make to the joint project of governing. In order to reconcile that contribution, the legislative initiative as I called it, and the reviewing function of courts, we should be open to the idea that judges sometimes defer to the legislature. Now, I appreciate that deference has had a lot of bad press, judicial deference has had a lot of bad press, but in fact it plays a key role in my argument. I use deference I think that deference helps operationalize the division of labor between courts and the legislature. So let me say a few things, if I may, about how I understand it. So when I speak of deference, I have in mind two ways in which the duty of judges may be normatively affected by the decision of another body. First, courts may defer to that decision in the epistemic sense. That is, they may refrain from second-guessing an aspect of that decision or forming their own opinion of its merits. In this sense, epistemic deference has what I call a deliberative effect. It channels judicial deliberation. For example, epistemic deference can be grounded in superior expertise. Because there's this other institution which is an expert in, say, national security, epistemic deference may dictate that judges not second-guess that institution's national security assessments. Now, epistemic deference is primarily what gives deference a bad press among those who like constitutional review. But in fact, I think that it can be made compatible with constitutional review, provided it is partial, to use Aileen's apt terminology. What epistemic deference can achieve, though, is that it can help judges economize on their very finite resources and insulate from review those judgments, those legislative judgments that properly fall within legislative initiative. So that's the first type of deference. The second type of deference I call robust. The mark of robust deference is that it changes what is the right thing to do. It may make lawful a decision that on its merits is morally suboptimal. Now, robust deference on its own does not have any deliberative effect. It is perfectly possible for a judge to form an opinion that decision is suboptimal and still accord it robust deference. Now, robust deference is possible precisely because judges take part in the joint project of governing. They cannot simply ask themselves, what can I do to promote justice or protect rights? Rather, they must ask, what is within my power to do, given that I share the task of promoting justice with my fellow participants in the joint project of governing, and what is my role within that project vis-à-vis those other participants. The fact that the judge contributes to that project changes the moral state of play. It is possible that his power to review a legislative decision is now determined by balancing considerations regarding the content of the decision, say the fundamental rights implications of that decision, and considerations of institutional design, about the role of the courts and its relationship vis-à-vis the legislature. Considerations of the latter kind sometimes tip the balance, hence robust deference, hence the idea that I mentioned earlier, that in the name of the institutional dimension of legitimacy, we have to be prepared to accept discounts on perfect justice. So, courts must monitor and courts must defer. And it is our job as lawyers, but also our job when we are assigned that job as constitutional designers, to find the proper balance between monitoring and deferring, and devise legal doctrines that reflect that balance. We should give up on the quest for a general knockdown argument, either in favor of or against constitutional review. At the very least, we should not expect to find such an argument in political philosophy. We have multiple normative commitments to popular government and fundamental rights, and it is our institutions as a whole, not one institution or the other institution. It is our institutions as a whole that must honor those multiple normative commitments. Therein lies our protection. Thanks.
Thank you very much for this. And we now turn to our first commentator, who is Max Harris here from Oxford.
Thank you very much. Thanks to Crescente and the JDG team for giving me the opportunity to comment, and thank you to Dimitrios for writing this really interesting and enjoyable book. I think the book has many strengths and attractions. In particular, I think it dissects in a really honest and rigorous way arguments that feature prominently in the landscape of constitutional theory, whether those are Dworkin's arguments on principle and policy, or Waldron's arguments on the procedural credentials of legislatures. And I think in doing this, it clears space for better future work. I think it can be tempting when we're trying to elaborate certain theoretical commitments in constitutional theory to sort of grab at available arguments from people like Dworkin and Waldron, and I think your book warns us against this, and it sort of encourages us to look for better arguments. And I think it's helpful in providing a sort of architectural approach to constitutional review and giving an account of the shape that a good argument for or against constitutional review will take. But I did want to make some critical comments to generate some discussion, so I wanted to just make 4 brief points. First, about the method of the book, about moralized constitutional theory. Second, just very briefly, I want to say something about the tripartite separation of powers, the place that has in your argument. Third, I want to touch on your critique of Dworkin's account of courts as forms of principle and wonder whether that argument might be reformulated. And then lastly, to say something about executives. So the book sets out a method of moralized constitutional theory, a method that commits to being transparent about moral judgments and says that constitutional theory should satisfy conditions of generality and doctrinal relevance. And I think those are attractive criteria, and I like that the emphasis on moral judgments. Where I had a slight concern was in the comment which starts at page 21, that moralized constitutional theory necessarily has a justificatory edge. And I just want to describe one possible interpretation of this claim and explain why I think it could have some shortcomings. So you say, Dimitrios, that the approach taken, moralized constitutional theory, quote, helps affirm and consolidate our conviction that our more particular constitutional practices are not simply a random collection of arbitrary rules, but have a point that makes them worth adhering to. And you talk of moralized constitutional theory playing, in the words of Rawls, a reconciliatory role. And you draw on Rawls's claim that political philosophy can calm our frustration and rage against our society and its history by presenting institutions as rational, and you say maybe constitutional theory can play a similar role. So my understanding of this argument is that it tends to view constitutional theory as having a kind of rationalizing tendency in relation to constitutional doctrine, and that when we are doing constitutional theory and applying it to doctrine, that we should find or seek to find a sense of order and coherence. And the first thing I want to say about this is that this tendency towards rationalization or even legitimation doesn't seem necessarily to follow from the original tenets of moralized constitutional theory that you lay down. So I think we can be open about morality, committed to generality and doctrinal relevance without needing to rationalize doctrine. The second query I'd have is whether there ought to be some limits to this rationalizing mission. And I can imagine you saying, for example, that where a collection of legal rules is manifestly disordered, that constitutional theorists should be open about this and say so. But I'd say that even if there were these limits, and I'm not sure they're expressly spelled out in the book, even though they might be implied, that this rationalizing tendency has some real risks, I think. I think if we tend towards seeking coherence and order in doctrine, there's a risk of attributing too much skill to judges. There's a risk of inaccuracy in describing doctrine, a risk of downplaying missteps and ambiguities of doctrine. And all of these risks, I think, can leave scholars and lawyers and judges overly complacent about the law as well ordered, and it can leave us insufficiently critical of the law as a whole. I think there is a tendency in constitutional theory towards, at least British constitutional theory, towards this kind of rationalisation and legitimation, and I think some of these risks have been realised in other work, and I think of some work that I've done on the law of the prerogative, which is praised by Dicey and Blackstone as part of sort of genius of the British Constitution, but when it's inspected more closely, is full, in my view, of indeterminacy and uncertainty and unanswered questions, and I think some of these unanswered questions haven't been brought out because of the push towards rationalisation. The other small point to make is that I think one of the drives behind this rationalising tendency is the Rawlsian sense that frustration and rage about our society needs to be calmed. And in my view, that's wrong. I think anger and rage can be a productive force in scholarship, and which can move us towards better constitutional doctrine. And so I wonder whether constitutional theory need not necessarily be a device of reconciliation, it might instead be a device to direct our critical thinking energetically towards seeing gaps between ideals and practice. So I hope that fairly renders your point and offers some possible risks, but feel free to tell me if it doesn't, either of those ones. The second thing I just wanted to say briefly, and in a way this is unfair because you don't focus this on this point too much in the book, but was about the tripartite system of the separation of powers. So in chapter 2 you say, it's essential for the establishment and maintenance of political liberty that the government be divided into 3 branches or departments, the legislature, the executive and the judiciary. And you move on to focus on the relationship between the judiciary and the legislature. But I do wonder whether this claim is a claim that political liberty can only be established and maintained through this tripartite formulation, and whether you think work on separation of powers needs to engage more with the assumption that this traditional formulation is the best one. In my view, there is a sort of prior question of how we delimit the territory, along with a question of how that territory is organised, and if we get that initial delineation of the territory wrong, I think it does have implications for the relationship between the actors within it. And I think there is really interesting work, in particular recent work on rethinking that traditional formulation. So Stephen Sedley has talked about whether the security and intelligence services might be a 4th branch of government. Others have talked about agencies, in particular in US constitutional law. Others have talked about local government as a further branch of government. Kevin Tan from the National University of Singapore has talked about the army and the need for constitutional scholars to engage more with the army. And I'd just be interested in your thoughts about this and whether we should be thinking more about this before we talk specifically about the relationship between branches within that framework. That might be slightly unfair because it was just a passing comment in your book, but I would be interested in your thoughts on that. The next 2 points I was going to make are probably a little blander, but I just wanted to touch on your critique of Dworkin. So I found your critique of Dworkin crushingly compelling, but I wondered whether there was a way of reformulating Dworkin's argument on courts as a forum of principle in a slightly more attractive way. So your critique of Dworkin here is that the court, to simplify, I think that courts, of course, engage with issues of policy and matters of policy, and that were we to redefine principle and policy to avoid that problem, we would end up with an uninteresting distinction, which renders Dworkin's approach here unhelpful to answering the questions at the heart of your book. And I just wonder whether we might slightly specify the Dworkin argument, or slightly refine the Dworkin argument in the following way. So I wonder whether we could say, and this is not something I've thought enough about, I'm going to be breezy now, but whether we say that courts are not general forms of principle, but forums for considering the effect of constitutional principles on the general law, where constitutional principles include human rights as well as other principles such as the rule of law. And we might say that the courts are a preeminent body for undertaking this consideration because the legislature has assigned that role to them. So this is a variant of a familiar argument. But we might say that courts are not born with any greater expertise, but that from being assigned this role by legislatures, they've cultivated expertise in fitting constitutional principles into the broader law. And we can say they've demonstrated that expertise in developing doctrines of proportionality, or doctrines of what constitutes a violation of rights, or in developing remedies for rights breaches. And I think we might draw some support for this sort of reformulated version of Dworkin in an unlikely place in Joseph Raz's work, in particular the essay, The Politics of the Rule of Law and Ethics in the Public Domain, which I think is a really interesting essay. And there, Raz says, the function of the rule of law is to facilitate the integration of particular pieces of legislation with the underlying doctrines of the legal system. And he says this view assigns the courts an active role in interpreting the law, and a role which may appear to be undemocratic, because it involves the courts taming the democratic legislature, but is supportive of democracy because it ensures coherence of purpose in the law and satisfies the need to mix the fruits of long-established traditions with the urgencies of short-term exigencies. And yeah, I wonder whether combining this account with the kind of germ of an account that I've sketched out might provide a better version of the Dworkin argument, if that's not too far from the original Dworkin argument. It could be said that courts themselves have often arrogated powers rather than being granted them. So I think about Marbury v. Madison, or courts in New Zealand, where I'm from, and their role in interpreting the Bill of Rights Act, but I think there are arguments back at that about implicit consent being granted by the legislature. And I think this account would satisfy the desiderata that you lay out in your book. So Dimitrios says that I think a good account of the relationship between legislatures and courts should satisfy three desiderata, namely distinctness, interaction, and political legitimacy. And I think this account does offer a distinct role for legislatures and courts. It accounts for some level of interaction, and it might be seen as politically legitimate on your view. So we're interested in your thoughts on that. And then just in closing, I realize I'm coming to the end of my time, I just wanted to say something about executives, because I work a little bit on executives. And you do bracket out the executive in chapter 1. But I wonder whether the account that you give of legislatures in chapter 6, which I think is the heart of the book, might be seen as treading on the toes of the executive in a way that means that the executive can't truly be bracketed out. So you say that the legislature can be seen as a moral pioneer that is both accountable and that undertakes moral innovation. And I think on its own terms this is a very attractive account of legislatures, but my concern is that this displaces the role of the executive. The executive is often seen to be accountable and to be undertaking moral innovation. Indeed, to use your words, it's often thought the executive has a sense of initiative in determining legislation. And we might even say that executive is better placed to be accountable and to undertake moral innovation and initiative. And I would just be interested, despite your fair bracketing out for the purpose of focus, and whether any future work you might do could reconcile your account of the legislature with what I've said about executives. But thank you overall for a really thought-provoking and incisive book. I learned a lot from it and really enjoyed reading it.
Thank you. And I think that we should move over to the next commentator before you get a chance to respond. So.
Yes.